Welcome. Welcome, everyone. Welcome to the Law, Your Money, and You. I'm Roberta Saphire, an attorney in Sharon, Massachusetts, New England, USA. And
hi, I'm Camille Barron. I'm a financial coordinator and a healthcare advisor, also in all those places that Roberta just said. And Roberta, I think the topic that we're going to be discussing today, we've had guests, many guests actually, talking about the same topic, estate planning, and yet there are so many nuances to estate planning that every time we have this topic, there's always something new that we haven't heard before.
yes,
Absolutely, I'm sure that is, because it really covers a lot of ground.
that's Jennifer. Jennifer, let me
Hi.
introduce you, but that's okay. I said to Jennifer before we started, I gotta warn you, I'm an interrupter, and she says, so am I. So it's great. Jennifer is great. We all have to sit up so that we're centered
Yeah,
there.
okay. Sitting up and being present. I'm Jennifer Deland. I'm a Massachusetts
Okay.
attorney in Holliston, which is a little town not too far from Framingham, which is outside of Boston, if you're trying to get your bearings. I'm very glad to be here.
We're happy to have you. Tell us a little bit more about yourself
Okay, I have a little office that we do estate planning, and that turns out to extend also to probate, which is when a will or somebody doesn't have a will and things need to be settled. It also extends to lately conservatorship and to Medicaid planning, which can be part of estate planning that people sometimes want to think about.
I don't know, shall we start with what's the difference between the Medicaid planning and the estate planning?
All right. So when people come in, they have a variety of issues top of mind. And one of the common ones is what would happen if I went into a nursing home? Would the state take my house? And how can we prevent that? Then I talk to them. First of all, I always talk to people about regular old estate planning, because all of this Medicaid planning is something you do on top of that. But if somebody is really concerned about that, then I talk to them a lot about my favorite estate planning tool, which is an irrevocable trust. Sometimes we call them legacy trusts. Informally, we call them sometimes house trusts, though they can hold other things. What it is a way of making your gift and starting your 5-year clock running for Medicaid without actually losing total control of the situation. And,
Making a gift to who? Making a gift
to who you want it to go to. Usually people are
Okay.
concerned about their children, but sometimes it's nieces and nephews.
What 5-year? What's the
That's
5-year?
right. And the 5-year look back, if you go into a nursing home and somebody needs to pay for it and your income is not enough, then you can apply for Medicaid, which has a program for paying for long-term care. And when you do that, they want to make sure that you've already spent most of your money, and they want to make sure that you haven't given it away just in order to make yourself eligible. So they have a whole bunch of very complex rules about how this can be done. But one of them says that they're not going to look back further than 5 years. So if you can make something, make an arrangement and manage to stay home, you don't either have to stay alive or necessarily stay healthy, but if you can arrange to stay home, not to need expensive professional long-term care for 5 years, then you're good. Okay, but the thing is, what if something happens? What if there is a change in your situation? What if you decide you want to move houses? By having the type of trust, Medicaid trust, we don't call them Medicaid trusts, never call them Medicaid trusts. Legacy trusts that I set up, you can determine who the trustee is. You can change the dispositions for after you die. And informally, you can ask your trustee to do what you want, say sell the house and buy another one.
Trustee, can you be your own trustee?
You can, but I don't generally recommend it. I recommend that you at least start with somebody else's trustee. But I did have success with a lady whose trustee decided he was too lazy to deal with closing the house. So she made herself her own trustee and then changed it to somebody else when she had to go into a nursing home. It worked fine.
Are there such a thing as annuity for the Medicaid?
Annuities are usually used when you are actually going into a home. This is not a pre-planning thing, but I do manage people's going into a home and handling the interaction with Mass Health. So I have done these annuities. What it is an annuity that pays out to the community spouse, the person who's not in a nursing home of the couple. And after that person dies, the remainder of the annuity goes first to Mass Health to pay off what they spent on you. So it's not a way, it really doesn't rescue your legacy, but it can stretch your situation a little bit and make things a little more comfortable for your spouse. Because when you go into a nursing home, Mass Health wants you to give all your income to the nursing home. And
What
if your
about the
spouse was
people-
counting on that, that's tough.
Here we go. What about the people who don't have a spouse but a partner? And that's the way it's.
Okay, well, the
Lord,
good
what do
news
they
if
do?
you have a partner and you're not married is that what they do is their business. Okay, the bad news is you can't just transfer assets to them. It's like giving it to anybody else.
Oh.
5-year look back time. I have dealt with people who are partners. Basically, Mass Health sees the person as single. But if you're married, and of course you can be married in a same-sex marriage, that's fine, then Mass Health wants to look at the assets of both of you, but you can transfer assets to your spouse, and your spouse is allowed to have a certain amount of assets. So we can do some
Interesting.
we can do some planning that way. If you're completely single and you are over assets when you're just ready to go into the nursing home, we look at things to spend money on that Mass Health will think is all right. You can hold on to your house if you think you might go home, and I recommend that people say they think they might go home unless there's a reason not to. You can. This is if you didn't do Mass Health pre-planning with me and put your house in a legacy trust. But if you didn't do that, you can hold on to your house. I had one lady who has a trailer, and I think she's still got it, and her son is still living in it, and it is fine. It is treated as if she was going to go home. She's not really going to go home, but it's okay because, we don't know. We don't know the future, and we don't pretend that we know. Unfortunately, Mass Health doesn't insist that we think we know. So you can take care of your house. If it needs a new roof, new heating, you can do that. If you still have money left over, you can put it in a pooled trust, which is a special kind of thing. Again, Mass Health gets what's left out of that, but in the meantime, it's available for whatever you need that you're not going to get otherwise. So it's a cool thing. There are a variety of things we can do, in other words. However, if you come to me and you want to do all this Medicaid planning and you just want to do Medicaid planning, I'll say, stop. The first thing you need to do is healthcare documents. And sometimes people are like, oh, why do I have to do this? Well, because you need to name a healthcare proxy to manage your healthcare. If you are in a nursing home, if you're having Alzheimer's or something like that, you need somebody who is able to make a decision and work for you. You need to give that person at least some broad directions, and you need to make sure they can get information. You also need powers of attorney so that you have somebody who can actually say to the nursing home if they're messing up, we'll sue, okay? Because you need somebody who actually has that power. But you also need a life or revocable trust. This is not optional. You absolutely have to have that, because if you let your money go through probate and there's just a little bit left, say, or say you were planning you were going to you were going to return home, but then you die and the house goes through probate, Mass Health will make a claim. Now, Mass Health doesn't like these revocable trusts. They will make you take it out if it's in the revocable trust, but it's still a good idea to have. You can keep your bank account in there, and a surviving spouse there's nothing after the person in the nursing home has died. There's nothing to keep the surviving spouse from putting the house into their trust, so it passes to the children without any probate, without any mass health lien. So it all kind of, it's a big area, but it all really comes together. And I have ways of handling all of this in a way that is just not overwhelming for people. It really works very well.
I have a question that, and it comes from Rebecca, who started all this, and I think Camille agrees. But the homestead advantage, is that lost by putting the real property in a trust?
Okay, so I have in my system, what I do very early on in the planning, say where we're at, healthcare documents. Okay, my planning always works by a series of meetings. So we're doing healthcare documents, but suddenly I pop up with, you don't have a homestead on the record, why don't you put one in? Okay, so I do the homestead and we file that. Okay, then when you go to set up your trust, you're doing a legacy irrevocable trust, in the deed you reserve that homestead. That should keep it so that there is not any problem. It does not replace the homestead, doesn't make the homestead go away when you transfer the home to the trust. And often people feel more comfortable about this because, again, it's their house. It may be a lot of what they've worked for over the years, and they don't want it to just disappear. So I always want to make sure that people understand what they're doing and that they are, kind of maximally protected. I really don't. One of the things that doing the homestead actually does is make it harder for your trustee to actually sell the house if you had not intended that to happen, and it's a good thing to have.
And the example that you gave a little bit earlier, Jennifer, let's say you have a couple and they do have an irrevocable trust, the house is in that, and let's say the wife, the woman has to go into the nursing home and is expected to be there, maybe however long. Yeah. So the husband is living in the home, and he has accumulated assets from working, et cetera, retirement plans, but he has those either separately or in a living trust. So when his wife goes into the nursing home, are his assets subject to Medicaid taking?
Absolutely, they are. There is absolutely nothing you can do about that. What I would recommend in that case is that we turn those assets into one of these annuities so that he gets that income. Okay, and the main thing is to make sure that he's comfortable and taken care of. We have a situation like that actually ongoing that I've been helping in my office. She is in a nursing home, but he is in a different assisted living type thing, less expensive than a nursing home, but more expensive than just rent because he's got people, housekeeping and looking after him and stuff. And so in order to make sure that he could afford that, we did when we did sell the house and turn it into one of these annuities. So he has extra money coming in. There's a lot of adjustment that often needs to be done. And it is kind of tough that they seem to think that, you should spend your entire retirement. This is why it's important to consult an attorney. Because if you listen to other people or people in the nursing home, they'll tell you, you just have to spend it. You don't. You can organize it in such a way that you don't have to spend it all at once. And this is a good thing.
What about if you want to make charitable contributions during or after and it's set up in your will already, or if you want to make it through your will, or if you want to make them while you're still.
Okay, so charitable contributions and mass health. If you are, say, in the habit of giving $1,000 to the church every year, you can keep on doing that, and they will not see that as a gift with a look-back issue. After somebody is in a nursing home, your budget is going to be kind of tight. It's unlikely, unless your income is to the surviving spouse is more than what Mass Health claims as patient paid amount. And that might be the case if there's an annuity. You might be able to make some charitable contributions, but
We might
It's
need
not
you more
really.
than one time. We might need you more than twice on these subjects, especially once you get into the probate. What did the probate, did that change so that stepchildren get something now too? Or am I?
Probate is,
crazy?
no, this is a completely different topic.
Yeah, that's probate.
Probate is a thing that there have been some changes. You're talking about what happens if somebody has no will and they die, and if they had children who were not the children of their current spouse, those children get a look in. The current spouse's children are not relatives of the dead person. The deceased person's stepchildren don't get anything. But what will happen is the surviving spouse's stepchildren, yes, they get a look in, which is good. And this is a common thing. Something that I always want to think about with people when they're doing their planning. What happens? Think about, who you consider to be your children, and think about what happens when you die and your partner may lose kind of connection to your children. Maybe you want to make a distribution at your death. People make the decisions that they make, but it is a thing that should be thought about, because people can feel awfully left out if their parent dies and the person that they were married to at the time takes over, and that's their step parent.
Yeah, I had a friend once. She says, "Do you believe it? My father's new wife, her daughter was wearing my mother's jewelry." I said, "Well, she should."
I cannot keep people from doing this kind of thing. I can encourage you to leave a what we call a special stuff list, a list of things that you want people to have. Okay, and it's incorporated by reference into your trust and into your will. That's supposed to happen, and it will help. Okay, so if you have a lot of jewelry and you want it to go to, say, your daughter-in-law, if you put it down like that, it will help. Okay, but people have a tendency to pick up and walk with stuff. So one of the first things I usually tell a trustee is think about changing the locks and letting people know that they cannot walk with things. The decisions are yours. It's tough.
Yeah, they cannot walk.
I mean, the other thing is, how do you get rid of some stuff that you may have liked a lot, but nobody wants? Okay.
Yeah, I got that. Nobody wants my stuff.
Okay.
Yeah,
So people say nobody wants it, but I always tell people, make a list anyway, because when my father died, I gathered up a lot of stuff that nobody wanted, and I'm not sure why. It's just a thing. Okay.
I mean, the kids, the children of older adults, when they die, people today don't necessarily have dining rooms anymore. They don't have, they don't care about the china or any of those things. People don't want it.
Yeah. Try getting rid of a piano. Fortunately, my mother moved and she got rid of the piano.
I got a pretty dining room set. Anybody want?
It's ridiculous.
That's funny. Boy, you can see you really know your stuff there. David, your assistant will be very proud of you.
Yeah, the question that a lot of people ask, and I think you very well answered it, is why, hey, I already have a will. What else do I really need? I have that. I'm all set.
Okay. So right now is really a good time to talk about that, because guess what I'm seeing in my feed of comments from my fellow members of the National Academy of Elder Law Attorneys. How long is it taking you to get a probate? I have this simple thing that I submitted months ago and I'm not getting it. Well, if you're waiting on the court to actually appoint your person so they can do stuff, you're going to have to wait. However, if you have named your trustee and in your trust, and you have titled, this is important, titled your property and your bank accounts to your trust, your trustee can go down and say, here's the trust, here's a death certificate, have me sign a signature card, put me on the account. They don't have to have been on the account, and they don't need a court order. It is a powerful thing. This is why I think even people who don't have very much benefit from having a revocable trust. just because it allows transition without you having to wait for the court.
All right,
And you
now
know what's
go
really-
into, I'm sorry, go ahead. I was gonna say
You know
revoke-
what
revoke
is
the
really
bill.
annoying, and I'm sure you've run into this many times. You know, I was a health insurance advisor, and particularly Medicare. I counsel people on which Medicare plan and so forth. And you tell them something, and then they say, no, I'll do it this way. And then they run into a they run into a roadblock, like you just said, and you feel like saying, I already told you this. Why didn't you listen?
Okay, so this is why I have several meetings, okay? Because I'll tell you to do something, you'll go and do it, or you won't do it, and that's okay. I do not bark at people. I say, okay, do you want to try that again, or do you want to just drop it? I also adjust. Sometimes I had one fellow who came in, he had written his will. He just wanted me to notarize it. And I looked at it and I said, this is not going to fly. But what I did was I took it, I added some stuff here and there, and put a proper will should have these two signatures and
all over,
the
really.
whole thing, attestation clause. And we did his will. Okay, then I said, okay, you okay now? Okay, can we do healthcare documents today? We did those. We did the powers of attorney, and then we did the trust, and then we did a new will that said, trustee, you're in charge. And it worked fine. Sometimes I just have to allow people to have their crotchet and, kind of find a way through their psychology, because it's a psychologically hard thing to do. And I really feel that it's important to meet people where they are and understand what their concerns are. Sometimes they're like, I don't want to do the healthcare. All right, we'll start with something else. I have enough flexibility that I'm able to do that. And so I always want to see what people have already done and what they're thinking about. And if they bring me a whole bunch of drafts and things, this tells me where their thinking is so that I can work with that. But it is often a thing that I think some lawyers are just not quite as into as I am. I really am into taking people from meeting to meeting, getting them to know them better, having them become more compliant, to the point where they're like, oh, I did that right. I have learned what you have taught me. I had somebody who just bought their new house, and I gave them all the directions about how to get it titled to their trust. And we know what's up. They're just so proud of themselves. And but it's not something that happens, on one meeting or two meetings. It happens over time when they come to trust your instructions and understand why you're asking them to do the things you're asking them to do.
I got a question. In this day where people get married multiple times, and this one, is there a way to ensure that you want the spouse, your new spouse, to get it, but you don't want their children to get it in any case? You want your children, what can they do?
You can make plans to avoid that issue, to allow to limit the access of the spouse to the assets. It is something that I often find that people are actually reluctant to limit too much. But one of the things that I often suggest is that they consider looking at their retirement and maybe having their children named on some other things. And I really want to, because I'm working usually with the two spouses. It's usually the present spouse doesn't want to be too limited, and I understand that. What I like to do is help them to think about making a plan that includes all children of both of them. And where one of them has some children and one has some, they're often willing to do that. I think I've had one situation where one party had no children and they were happy to have their stepchildren essentially be the heirs. But in that, you really have to make it clear in your documents that that's what you intend. And so that's one of the advantages of working with a good counseling lawyer.
But once you get the spouse who dies and their present spouse gets it, once they get it, it's what they do. They can have their own children.
Absolutely, that is true.
Yeah,
that's another reason why I suggest, arranging some at least small group gifts to happen immediately on your death rather than waiting for after the spouse dies. Families differ. Some people are perfectly willing to, as I say, distribute among all the children. But it does happen sometimes that the surviving spouse is like, I don't really have a relationship with those people. Let's drop them out. And there's nothing, you really can't keep them from doing that,
Well, I got one thing to end on, because we got about 5 minutes, but you can do a lot. What about where you have husband and wife, and they have sons, and they have sons, they have daughters and one son, and is it unusual to have the daughter left out? In other words, not the daughter, the daughter-in-law. The daughters are getting stuff. The daughter-in-law's been a daughter-in-law for years, and they just leave them out. Is there any? Do you ever advise them to say?
I kind of suggest that you might want to give a gift to a daughter-in-law, especially when we start with the planning for health care, and the daughter-in-law is the one who's going to be the point person, and then we start talking about, well, who's actually going to handle the money, and it becomes clear it's really going to be the daughter-in-law's job. And then I start kind of encouraging an arrangement that would allow her a role. Often, though, if you say that people want to leave things to their grandchildren, if you leave that in a trust with the daughter-in-law trustee, in case the son passes away, or with both of them trustee, that can be better.
That's interesting.
I can't make people make a different plan than what they want to give, and I have had the case where, I always ask the couple separately who they want to be their person, and always the guy is like, my son. And it's been pretty clear from what I have learned about the family that the son is not really that involved, but I can't.
No. Well, we have to have you back, because if not for your wonderful knowledge, your great personality.
Oh, thank you so much. I am very enthusiastic about this, and I'm glad that you find it interesting.
Yeah, Camille, I leave it to you to wind up as you usually do. Camille's wonderful.
Oh, thank you. Yes, Jennifer, I think we just barely get the top of the iceberg.
Oh, yeah.
I think your approach is a little unique, and I like it. I like it a lot, the series of meetings, and people get overwhelmed very easily.
They do, yeah.
Give too much at one time.
Yeah, and the response to overwhelm is just freeze, and that doesn't help. It's really helpful if you can kind of keep gliding on to the next thing and make it a relatively easy trip. It's
terrific.
Good.
Terrific. Thank you so much for sharing your knowledge with us. And I'm sure our viewers are going to enjoy watching this episode. And to our viewers, thank you for watching. If you have any questions, please let us know. And also, if you have any ideas or suggestions about future topics, please let us hear from you. Because remember, this is your show, the law, your money, and you.
All right. Thank you.
Thank you. Thank you.